Hey guys, I got the camera off for this one because it's the middle of the workday, so I have to make this one short. We're still waiting on the judge's ruling on the motion for summary judgment and the motion for judgment on the pleadings in the Blake Lively versus Justin Baldoni and Wayfarer case. And while the parties are waiting on that ruling, which will hopefully narrow things down before trial, we've had some extensions for the pretrial motions that they need to file. It was initially supposed to be due tomorrow, I believe. Those deadlines got pushed out a week, and then now we're seeing an additional 1 week for the parties to file these initial motions. That's because they're having some disagreements behind the scenes with the kind of exhibits and such that Blake Lively is submitting for trial. I'll go over the reasons why they asked for an additional 1 week extension in a second, but first I'll show you what the judge had said to this request that the Wayfarer parties made last night. He granted the extension request, so the initial motions will be due now on April 10th, and then it says the court will hold a video conference on April 2nd. Of course, the public will be able to dial in and hear that one. So the request I'm about to read to you, it's already been granted. But here are the kind of shenanigans that are going on behind the scenes. It says the Wayfarer parties submit this letter to seek a further 1 week extension. Lively does not join in these requests. The Wayfarer parties remain fully committed to moving this case forward and are working steadily towards that end. At the same time, they respectfully submit that all parties would benefit from additional time to prepare submissions with a degree of focus necessary to facilitate the trial process and aid the court. From the perspective of the Wayfarer parties, there are two reasons for the proposed extension. First, more time is needed because, in working towards a joint pretrial order, Lively's counsel has made voluminous disclosures that are not practical for trial purposes and exceed the bounds of any conceivable evidentiary presentation. Just after midnight last Friday, for example, Lively's counsel identified nearly 1,000 purported trial exhibits for inclusion in plaintiff's portion of the pretrial order. It is difficult to imagine that even half that number will be put before the jury. Many are lengthy exhibits consisting of numerous text messages or pages, many of which are obviously irrelevant or inadmissible under multiple rules, without specification of what particular messages or materials might actually be introduced. Due to an apparent technical issue, Lively's list of potential exhibits also does not make clear on which page each exhibit ends and whether attachments referenced on the face of the exhibit are intended to be parts of the exhibit as well. Of the nearly 1,000 exhibits identified, at least 100 consist of articles and social media posts that were not produced in discovery and have yet to be provided to defense counsel in reviewable format. And you guys know I'm not an attorney, so as always, I have a couple questions. This 100 articles that were not produced in discovery, is that reasonable? I think that don't you have to use stuff that was produced in discovery? We'll talk more about that when I finish reading this here. It's not much longer. Wayfarer's counsel brought these issues to the attention of Lively's counsel in a meet and confer earlier today, and Lively's counsel is investigating possible errors and taking steps to complete the production. However, Lively's counsel declined to reconsider the scope of their production, maintaining that the volume is appropriate. The same overbreadth is reflected in Lively's identification of in excess of 40 trial witnesses and in Lively's designation of broad swaths of deposition testimony that include plainly inadmissible materials, such as testimony in which witnesses profess a lack of knowledge or inability to recall, state opinions as opposed to observations, review and discuss documents or events they have no personal knowledge of, or otherwise address matters that are at best tangential to the case. The purpose of pretrial work is to hone the issues and tame the excesses of discovery into a form that is presentable at trial. Lively is the plaintiff, and at this stage of the process, should know her order of proof close to the manner in which it will be presented at trial. Defense counsel should not have to sift through a document dump of exhibits and designation containing voluminous amounts of plainly inadmissible material during a compressed period of time when the parties are also tasked with drafting motions on a range of issues. Nor should time be spent on motions in limine to screen out irrelevant, prejudicial, and otherwise improper material contained within hundreds of exhibits Lively may not actually use at trial. And for those of you who have never seen anything like this before, a motion in limine is a pretrial motion. They want to exclude specific evidence or arguments from being presented during the trial. So they're saying they want a conference with the court, which the judge has now agreed to next week on April 2nd. They want a conference with the court because they shouldn't have to spend all this time to write motions in limine to screen out things that are obviously irrelevant and improper. Okay, we're almost done with this letter here. Separately, the parties are still working together to prepare jury instructions. The current draft is lengthy, comprising approximately 85 pages and covering all 13 currently remaining claims, associated defenses, and related damages issues. Conferring on and drafting appropriate instructions and explanations for any competing positions will require additional time. Second, it may also be easier to achieve more focused pretrial submissions once the parties have the benefit of any narrowing of the issues or further guidance that the court's ruling on pending dispositive motions may provide. For example, the Wayfarer parties maintain that, in light of the uncertainty about the scope of the case, it is premature for the parties to confer over a verdict sheet at this stage. For the foregoing reasons, the Wayfarer parties respectfully request a further 1-week adjournment of the pretrial deadlines as follows below, as well as a Zoom conference to discuss their concerns. We note that this proposed schedule would also necessitate moving the final pretrial conference currently set for April 21st. And then the judge approved of these proposed deadlines here. So my impression of this letter is that it's not really just about scheduling, but it's also about the kind of attacking her approach. They're saying that she's dumping evidence, she's ignoring some rules, and she's possibly violating discovery obligations. On the top of page 2 here, they're talking about these excessive and broad swaths of testimony that have plainly inadmissible materials. And that's just one of the statements here that makes it sound like they're, implying she's acting in bad faith and trying to overwhelm them. It sounds to me like they're saying that she's the one who's being unreasonable, but they're committed to moving forward with the case. And then, of course, again, as they've kind of been saying a couple times over the past few weeks when asking for extension, is that it might be premature to finalize these things before dispositive rulings. So they're kind of creating a record here to say that her case is like messy and overblown, and that Lively is overreaching and wasting the court's time. And again, this is just my interpretation of these things as an observer, as my opinion. You guys know I'm not an attorney, but there are plenty of attorneys who cover this case, and you can hear what they have to say about this. They seem to be alleging that there are, several, 100 about, I think they said 100 proposed trial exhibits that were not produced during discovery. They're like articles or social media posts, and they're now being surfaced in trial prep, which is something that amounts to a rule violation. Discovery is not optional. They have to disclose the documents they might use to support their claims in discovery. And that deadline passed a long time ago. Because real life is not like, court you see on television. You can't hold the evidence back and then surprise the other side with it at trial. And who knows what the 100 articles and social media posts that she did not produce in discovery, what they are. It could be anything. She tried to subpoena a bunch of social media users. Some of them had like little to no followers. So she'll grasp for anything at this point. It doesn't seem like she has much hard evidence to prove any case of the alleged smear campaign. After everything that's come out in this case, it still seems that everything that had come out through the PR kind of war they had were true things about Blake Lively. And a lot of this was just standard PR stuff. So it actually doesn't surprise me at all that she's trying to throw a Hail Mary with 100 articles and social media posts. I mean, she tried to subpoena my bank account because I talked shit about her. As far as I'm concerned, she's got nothing. Anyways, it sounds like Wayfarer caught that issue. They gave Lively a chance to fix it, and it sounds like she refused to kind of narrow what she was putting forward. We'll have to wait and see what they say in the hearing next week. Maybe there's, some circumstances where you don't have to disclose publicly available like social media posts and articles. I don't know. I think it depends on how you use those things, but I guess we're going to find out soon enough. So that's all I got for now, guys. Like I said, not a huge update, but I did want to cover that briefly. So thanks for watching. Don't forget to hit the like button for me. It helps me out a lot, and I'll see you all soon. Bye.